Welcome to Fox Soul's Black Report with our continued coverage of the justice for George Floyd, the trial of Derek Chauvin. I'm Romeo.
Hey there, I'm Brooke Thomas.
I'm Demi.
And of course, Melissa, she is out today.
On today's report, we have a triple dose of Black Girl Magic. Minneapolis NAACP President Angela Rose Myers is here to discuss the NAACP's action plan for unrest in the city.
Also back on the show, Commonwealth's Attorney of Portsmouth, Virginia, Stephanie Morales. She is here and going to help us break down today's trial date with Derek Chauvin.
And St. Louis Mayor-elect Tashara Jones is here to talk about making history, race, and criminal justice reform. Soulmates, we have all of that and so much more. If you're ready, it's our voice and our truth. Let's get it.
To me, this reeks of conflict of interest.
Do we know if he actually waved a gun? We only hear one side of the story.
This just really did make me feel good that the justice system did what they needed to.
So we're going to keep following this story, and we will have the latest for you.
The head of Minnesota's largest police union heavily criticized the city's government officially handling of the deadly police shooting of Daunte Wright, a 20-year-old black man, and blamed the victim's actions as one of the reasons he was killed. This is going to be an unpopular statement. Brian Peters, executive director of the Minnesota Police and Peace Officers Association, said Wednesday in an interview with WCCO News Radio. Daunte Wright, if he could have just complied, he was told he was under arrest. They were arresting him on a warrant for weapons. He set off a chain of events that unfortunately led to his death, Peters said. Kim Potter, the former police officer who fatally shot Wright during a traffic stop Sunday in suburban Minneapolis, has been arrested and charged with second-degree manslaughter.
Also, Soulmates want to let you know, also being heavily criticized right now, the mayor of Chicago, the police in Chicago, as the investigation of the fatal shooting of 13-year-old Adam Toledo. I just want our Soulmates to know we are following this story for you. All right, moving on. We now know Derek Chauvin will not testify in his own murder trial. The former Minneapolis police officer invoked his Fifth Amendment right not to testify today, and this ends weeks of speculation, also bringing the defense's case to a close. Chauvin is charged with second and third degree murder as well as second-degree manslaughter in the death of Floyd. Closing arguments will start Monday, and at that point, the case is handed over to the jury for deliberations. Portsmouth, Virginia Commonwealth's Attorney Stephanie Morales is back with us today to break everything down. Thank you so much for being with us here this afternoon.
I got my time back. Thank you for having me.
It's great to have you. Before we get into today's proceedings, we have a lot more that we also want to touch on with you. We just reported on, you heard Demi there, Brian Peters, executive director of the Minnesota Police and Peace Officers Association. People are talking about this, upset about his words, essentially saying, had Daunte Wright complied, he'd still be here. I want to just absolutely, as a prosecutor, get your thoughts on this.
So I denounce that line of thinking. First of all, we have seen so many instances around our country, including recent events where police can show restraint for non-Black people who do not comply with them. And so we have to be very clear that that line of thinking is dangerous. Instantly, we have this conversation brought on by police officers about compliance. And we see, very many instances of individuals complying and they still die. And so having that conversation around compliance, it is what we refer to in the law as a red herring. It's to throw people off the scent. And I think all around the country, Black people, people of color are exhausted, tired, and fed up with hearing things that simply don't make sense. Police unions are individuals who are tied into law enforcement. All members of law enforcement have taken an oath to serve and protect. And so quite frankly, anyone who is tied into law enforcement who does not care about the lives of individuals who are dying at a high rate at the hands of those who are supposed to be there to protect them, I simply can't stand for that type of dialogue and conversation any longer. So as a member of the profession that has done a great deal of harm, I denounce that comment. Simply because you have not complied, that does not result in your death. This is the reason why we have laws and why we have rules. And if you do not comply, there are ways and means to hold people accountable within the law that do not result in law enforcement acting as executioner.
That's true. We saw what happened to the 61-year-old white man not too far from there and what he did to police, and he's still alive. So what do you expect from fellow public officials in this moment?
So what I really want to see is public officials denouncing this type of behavior and then acting on it. If you have the budgetary authority to take law enforcement resources and determine whether they are actually being utilized to keep communities safe, or whether that allocation needs to be rerouted into community investment, to ensure that our communities are actually safe from everyone, including state actors. That's the type of action I want to see that comes behind the word. I think a lot of politicians and elected officials are seeing that community members are tired and they're learning what to say. But I think also our people don't want empty rhetoric. We don't want platitudes. And I say that as an elected official. If you're going to talk the talk, be willing to back it up. And as someone who unfortunately had to suffer a great loss in my community, when it was time for me to indict an officer and prosecute him, I sat first chair because I believed in putting action behind those words, that we were not willing to tolerate violent acts by police officers unjustly to our members of our community. So what I want to see from my fellow elected officials are that they denounce these acts, but that they put action behind those words and they do everything within their power to ensure that the members of our community are safe in general and are safe from law enforcement members who simply do not care and value the human life of members of our community like Daunte Wright and like George Floyd, so that no mothers have to experience the loss that Daunte Wright's mother has experienced, and that no children have to lose their parents because members of law enforcement don't fully understand how important it is for them to value the human life of those members of our community.
Can you get into some specifics on how they back that up, right? Because, obviously, and I don't want to put everything on you because I know you can't fix everything in the entire system, but, you know a lot about it. And obviously our current criminal justice system as it stands, it's not working. And we've spent decades pretending as if it will work. So have you seen the type of radical change being needed? Have you seen politicians, other city and state leaders putting systems in place that can actually, so that we can actually see change? Like, how do they back it up?
So first of all, I have to make a small distinction. This system is working. It's just working exactly the way it was designed to work.
I see what you did there. I see what you did there.
That is a serious problem.
Mm-hmm.
It is founded on years and years of systemic racism. And, the status quo is what's killing us.
Mm-hmm.
And so this system, it is not something that can be reformed or reshaped into something that works. It has to be transformed or torn down and rebuilt. But in the interim, while we have the system we have, prosecutors like me, there's nothing stopping those individuals from charging people, who have committed crime and doing everything in their power to hold members of the system accountable for their harms to the community. Also, those with budgetary authority. There is a mayor in Ithaca, New York. His name is Daunte Wright. He has done some amazing things in terms of how he changes his police department to reflect something that the community needs. Look at San Francisco. They have medical trauma response units that show up now for people who are in mental health crisis instead of sending police. And so there are creative ways that people are using their budgetary authority as council members, as mayors, as city managers around our country to ensure that the members of our community are not interfacing and interacting with law enforcement constantly, that we're not treating law enforcement officers as social workers, and that we're holding them accountable. We have people who are professionals, who are able to do certain jobs to provide resources for our community. But until we stop using policing and mass incarceration, as a fix for everything, we will continue to see people dying. We will continue to have unsafe communities, because we know that more incarceration is not making us any safer. All it's doing is disturbing and disrupting generations of families. So we have to use our power to hold people accountable, but we also have to use our power for those who have budgetary authority to, make those difficult decisions to protect the members of their community unapologetically. And if those, leaders are not willing to do these things, they're not the right fit for us at this stage, because we understand how damaging and how destructive and how much of a matter of life and death this is for the members of our community when we have people unchecked engaging in this type of behavior.
Stephanie, I actually want to switch gears just a little bit. I want to know your thoughts on the charges that were filed against Kim Potter, as you know, the former police officer that fatally shot Daunte Wright. A tough question for you. Would you have filed those same charges?
I would not have filed those same charges. Those charges are, surrounding conduct that was hinging on recklessness, which is basically what she admitted. She made a statement and it made it sound as though it was an accident. But for someone who was a 20+ year veteran and a leader within the police union, we know that this individual knows the difference between a gun and a taser. we can, reasonably conclude that. And, for me, I have to look at all the facts and look at what the probable cause says. And the time I was here prior, I talked about the fact that premeditation can be formed in an instant. And I think there's evidence to suggest that she made a decision about what she was going to do if this young man did not comply. And once again, whether he complied or not, that is not a grounds for her to use deadly force. And a gun is deadly force, so is a taser. And if you perceive some type of threat, you have to use your judgment to engage in an action that is proportionate to the threat that you perceive. Nothing that he did warranted the use of that deadly force, whether it was a taser or the gun. And so I believe that she had made a conclusion in her mind. If that happened in my city, I would be submitting to the probable cause, submitting probable cause to the grand jury for premeditated murder, which would be first-degree murder. And then at that point, it would be the grand jury's decision about whether or not they would bring the indictment for first-degree murder or some lesser included charge. And then if we got to trial with an indictment for first-degree murder, it would be the jury's charge to determine whether or not they would convict of that or something lesser. But I would not make that decision myself, because that's not what happens with the members of our community on every other case. If something were to happen in the street and someone were to have gotten shot and a person made an utterance that said, oh my goodness, I just shot him, they would not automatically conclude that it was an accident and let's give this person a recklessness charge. They would say, well, there's probably probable cause for premeditated murder. We'll start here and then see where we go. And so what I would like to see is that same accountability that the members of our community who look like us face on a day-to-day basis. I want that same accountability from members of law enforcement, just like I want that same restraint that we see for people who do not look like us, who are given opportunities from law enforcement that we don't get.
Stephanie, you are right about that. All right, let's talk about today's proceedings, okay? Let's take a look at this.
It's untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not due to bad faith. But the late disclosure has prejudiced the defense. It's not going to be allowed. So Dr. Tobin will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple. This late disclosure is not the way we should be operating here.
One of the last words we all want to hear in this trial. Why did the judge deny this line of questioning?
So all of us in legal proceedings are entitled to certain disclosures, but the person who is entitled to the majority of the evidentiary disclosures in advance are those who are on the defense side. So we have something we refer to as discovery, where we have to turn over, a lot of different things depending on what the law says in any given state. And across the state, you have to turn over scientific reports and evidence of that nature. My understanding is that there was a lab result that was produced, and that was not submitted to the defense in enough time, according to the judge, for them to adequately prepare for the testimony of that witness. And the judge concluded that allowing that to go forward at this stage would prejudice the defendant and his right, to a fair trial. And so that's a decision the judge made. And my understanding is the prosecution proceeded without having any incident that would have resulted in a mistrial. But that is very common practice for, everyone to turn over as much as they can as early as possible. And then if you do not turn it over early, you face the possibility of the judge determining that evidence is inadmissible.
So we finally got an answer. Big cliffhanger this whole time is, will Derek Chauvin testify? Turns out he will not. Take a look at this.
Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
You understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt. Meaning they can't say, he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Okay. Mr. Chauvin, I'm going to address you directly because the decision whether or not to testify, I'm going to take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of...
So, Stephanie, were you surprised that he chose not to take the stand?
I was not surprised, you know, with the way the prosecution's evidence has played out. And I think I mentioned this the last time I was here. It was going to be a very difficult thing for him to explain away all of the things that came out. You know, even if you did not watch the trial and you just saw the footage about what happened to Mr. George Floyd, there is really no explanation for his behavior and his conduct. And in having the conversation around, again, what I said earlier, where if you perceive a threat, the amount of force that you use has to be proportionate to the threat that you perceive. And at the point where that threat is no longer there, you have to stop. There was no real explanation as to why he remained in that position until Mr. Floyd passed away, and even after he passed away, as we learned throughout the course of this trial. And so there was going to be a serious issue with him being able to explain those things and withstand cross-examination. And so I'm not surprised that he exercised his Fifth Amendment right. And it's something, again, as the judge said, it cannot be held against him by the jury. But the defense's job would be to create confusion. And I think if he would have testified and gotten cross-examined, it would have been even more clear that what the prosecution was trying to prove would have been cemented by his inability to explain his conduct in any rational way.
Thank you so much for that, Stephanie. So today being Thursday, it ended very quick. The judge decided to adjourn court until Monday, though. A lot of people were wondering, we still have Friday. Why wasn't that considered another work day in court? Why do you think that he decided to wait until Monday for closing arguments?
Well, my understanding is what they're doing over the weekend is they will be working on jury instruction, which is a very important thing. And so, you know, we know that jurors go and deliberate, they hear all of the evidence, they will hear closing arguments. But one thing that's really important that's not often talked about is the fact that they will get instructions as to what the law is based on the charges, based on how everything has come out. And sometimes there is argument about what jury instructions will come in. And so the defense and the prosecution have probably already submitted jury instructions to the court. The court is probably making decisions. But it's really important that the jury instruction process be done thoroughly and well, that everyone put their arguments and their objections on the record about what jury instructions will go forward. And, you know, there are multiple charges here. And I think the jury has a difficult decision to make about what charges they will potentially find Derek Chauvin guilty or not guilty of. And so that is what jury instructions do. For example, we just saw the clip about Derek Chauvin exercising his Fifth Amendment right. There will very likely be an instruction there where the jury is told that they cannot hold that against him. That's an example. Another very good instruction that people don't know about is that we are often putting jury instructions in that say that you get to use your common sense. You know, that you can deduct things that you would reasonably conclude based on your common sense. So the jurors, hopefully they are people who bring a wealth of experiences that value human life, and they get to use their common sense as they make their deliberations. So jury instructions are very important. Also, the court probably wants jurors to be able to hear the evidence and hear the concluding arguments, and give them time to actually be able to go in and start the process of selecting a foreman, setting everything up, and deliberating without having a long break over the weekend. So that's commonplace when you have a trial of this magnitude, to get the jury instructions together, have the jurors come in fresh to hear the closing arguments that wraps up all of the evidence that came in, and then begin that deliberation process.
Okay, Stephanie Morales, thank you so much for being so informative today to our soulmates, and we're going to see you tomorrow, correct?
Oh, I can come back tomorrow.
Oh, well, we're going to try and make that happen. If not, have a blessed weekend for sure.
You do the same.
All right, take care.